medicine, and the Seattle cops were cool, and we didn't worry about anything. And then I come back here to Michigan, and in August, the McQueen decision came down from the Court of Appeals, and I just absolutely erupted. I hadn't played guitar and sung for 30 years, and all of a sudden, this song pops out of my baked brain, and I did it for all the patients. I'm a fibromyalgia patient, scoliosis, and big pharma stuff doesn't work for me. And so I hope that the statement that I created will resonate in your hearts as well. Thank you. Would you let your mother ride in green? Would you let your sister weep? Would you let your veteran brother moan and rage when they cannot sleep? For all of our big bad pharma who waste on the thing, and the outcomes of their high-tech medicine, the praises we can't sing. We're the desperate and despairing, for each other we are caring. Betrayed and abandoned ones with loving hearts like shining suns. So we found our own solution, green and pure and clean, free of chemical pollution. Oh, what soothing peace it brings. For all that disease management, some deem to call health care, and rapacious health insurance, stealing all they dare. We're the desperate and despairing, for each other we are caring. Betrayed and abandoned ones with loving hearts like shining suns. Would you close down our dispensaries and leave us all in pain? For all the suffering you impose, what riches do you gain? For all that has been lost through corruption by us all, we're patients, lost Americans. We'll help you when you fall. We're the desperate and despairing, for each other we are caring. Betrayed and abandoned ones with loving hearts like shining suns.
All right, thank you, Lee. That was great. All right, I'm going to introduce everybody in the panel very quickly, and then I'm going to ask individuals questions. Everybody else in the panel, if they'd like to answer or chime in after that person, to be fine. And if anybody has a question on that issue, you can ask from the audience as well. This is a great panel. Covered a lot of different aspects of what's going on and involvement in the process and making change and helping things out. We've already introduced John Targowski, attorney with Targowski and Crow. You can applaud each time if you want to. We have Brandy Zink here. Brandy's been involved in activism for a long time in Ohio, in Michigan. She works with the Cannabis Council, a lot of national organizations that we'll ask her about in a minute. We have Schneider, who's also involved in a lot of different organizations, including that. And we have Thompson, the editor of the Michigan Medical Marijuana Magazine, and part of the Advantage Management Group. We have Tim Beck, who, of course, has been around doing a lot of things for a long time and has been behind a lot of the stuff and is partially responsible for us being here right now talking about this stuff. And we have attorney Tom Levine, who joined us a little bit late. He's also of the Cannabis Council in Detroit and has a lot to say on a lot of these issues. And Joe Kane was going to be here. He cannot make it. He said to tell everybody how important it is to vote, and he'll make it to the next one. But I'll just ask a couple of questions here from some people, and as I said, if anybody else wants to chime in on the panel or ask a question from the audience, we can do that. John, when you were speaking earlier about some of the federal scenarios, you were mentioning that I'm not sure if that's going to be good for amplification. I'll hand you this one when I'm done. But you were saying that there's threats to the local officials if they license people, if they let them do this. While they may follow through with a threat like that, are there defenses? Is there any kind of legislative immunity that some of these people may bring up if they really did try to do that?
Currently, I don't believe there would be. I also don't really see a local official that's been sanctioned by like the state of Rhode Island or the state of Colorado to implement, enforce, and issue, business licenses and so forth pursuant to state law. I don't see them actually going to federal court, actually being indicted. I don't know. Maybe some people here would disagree. But in terms of any sort of statutory defense under the Controlled Substances Act, of course there's going to be a lot of arguments that they've, that there might be some argument, let's say, that they have some qualified immunities through implementing their own regulations, but, when you're in federal court, the federal government always wins. That's what the federal, that's, what's happening in a lot on Obamacare, that's what's happening on gun issues, and that's what's happening, we have a patchwork of systems. So realistically, I see what's happening more as them using it and then having local officials, local governors, or state governors, Schuette, Chafee, et cetera, then failing to implement those policies, those initiatives, those regulations, failing to issue those licenses. The state of Arizona passed medical marijuana in 2010. Their governor sued the federal government to get some sort of opinion as to whether she was allowed to enforce, whether she was allowed to issue these dispensary cards or licenses, and so far none of those have been issued. Patients may be protected, but their intended distribution system, their intended regulated distribution system hasn't been provided. So as I was saying during my talk, that's kind of, changing the paradigm for how the 2012, some of the debates in some of the states as to how what they should put on their tax and regulate ballots. Should they spend a lot of time putting in a regulatory scheme that their state government may not really, in reality put in, or should they just remove all penalties and create a vacuum and let the state legislature figure it out after it's passed? Anyway, I think I went far beyond the question.
Anybody else want to chime in on that, or anybody have a question? I think when somebody uses it as an excuse is my point, kind of. Like when somebody's saying, I can't do it, I'm getting, threats from the federal government. We can tell them, at the very least, nobody's ever really done that. They've threatened it, but they've never really done that so far.
If that actually happened, you would have the ACLU, any cannabis attorney here in the state, plus, National Association of Criminal Defense Lawyers, any number of organizations provide legal services to those threatened employees for free, not to mention, their state government. So I really am not, the threat of it being resolved, it's really just a political card, I think.
Thank you. Okay, Brandy. Brandy works with a lot of national organizations. We can touch on a little bit on that, but there was also a couple of federal bills pending that could be positive for us. Can you tell us what those are and what some of the implications are?
Thank you. Yes, there are several bills on the federal level, and so they've all been consolidated under the H.R. 2306 to limit the application of federal laws to the distribution and consumption of marijuana and for other purposes. And this bill would, it's called the Ending Federal Marijuana Prohibition Act of 2012. It's sponsored by Barney Frank and Ron Paul, John Conyers, Ms. Lee of California, Mr. Polis, and Mr. Cohen are all members of the House of Representatives. And this is being referred to the Committee on Energy and Commerce, and in addition to the Committee on the Judiciary. So there were other bills. One of the bills was to address the issues of the IRS trying to prohibit businesses, dispensaries, and other cannabis-related businesses from deducting their expenses of their business under some obscure code of 280E, which please ask a lawyer if you're going to be involved in one of these businesses, because there is a... No, I'm not a lawyer, although I work for some great lawyers. So please don't ask me legal questions, ask the lawyers. But the bills that are in the legislature now, some of them have been introduced before, and so this is an ongoing, we're trying to end federal prohibition, but there's another bill that's been introduced over and over to protect the state's rights to medical marijuana, and that would reschedule marijuana as well. And then the other bill that's being introduced would allow dispensaries, again, under some finance rules, to be able to conduct their business with banks, because a lot of dispensaries are being threatened with their bank accounts being forfeited from banks. So a lot of banks are saying no to doing businesses with dispensaries, and that's causing a lot of issues for legitimate businesses to do their banking.
Anybody else on the panel want to talk about these federal bills, or does anybody have a question about them?
Is it true that the Judiciary Committee already said that it will never get out of their committee?
That's probably true.
I would say that that's probably true. These bills have, in some way, shape, or form, there's always been, for the last 10 years or so, a bill introduced to address medical marijuana and then other marijuana policy reforms. It's interesting to note that the Gallup poll that was issued a week or so ago showed that the support for legalization has now crossed the threshold where 50% of Americans now support legalizing marijuana on some level. So I think that we're seeing now, we're coming to a point of critical mass where it is clear that the people are ahead of the politicians here, and so it's up to us to inform them, empower our legislators, and hold them accountable to listening to our will.
Excellent. Thank you, Brandy. All right, Robin's based out of Lansing and has met with several of the lawmakers, discussed these issues with them and municipal officials around Lansing as well. And Robin, why don't you go through some of that process, how people can do it, and how you've been successful with that.
Thank you, JB. Working with our lobbyist, Kevin McKinney, and really I think it's one thing to work with a lobbyist, it's another thing to have individuals going and meeting with their state reps, meeting with their senators, and now's the time for us to do the educating, and it's really our job and our responsibility to do the educating and make sure that our representatives know where we stand and what we want and why. I feel like you know, most of the bills that are in play right now are very restrictive, could actually do quite a bit of damage to patients being able to not only get their recommendation from their doctor, but also acquire their medicine. And the biggest thing I would ask all of you to do would be to start meeting with your own constituents, meet with your state rep, meet with your senator. Ben has some fantastic packets put together that will help you identify who your representative is, and a lot of times you can meet with them in their home office, so you don't have to travel all the way to Lansing, but they're usually generally pretty excited to meet with their own constituents. And it's just a matter of picking up the phone and asking for the appointment and going in, and typically our messaging has been, you know, please vote no on any of these bills. And we've gotten a lot of good response with that, and some willingness to possibly compromise, but we're still asking for the no votes. And I think our other messages is that patients deserve safe access to their medicine. They deserve to be able to go into a place with well-lit parking lots and security and acquire their medicine just like the law says we're allowed to do. We have some patients that, you know, have HIV or cancer, and they rely on those centers to make sure their medicine is mold-free and tested, and that's something that's really important to certain patients, and so we need to make that available to them as well. But like I said, it's been great having the tool to work with a lobbyist, but really what needs to happen is the grassroots movement. We need all of you to do the educating right now, and where we're at with the current bills, they've been delayed, so we won't be seeing any hearings on them in the near future.
That's partially due to these efforts.
Yeah, they decided to start working on a package of bills that would decrease the number of judges in the state. We can get another round of applause for that. And so we're looking at possibly January. But honestly, one of the things I learned when I was meeting with Representative Horn, who's kind of the point man, kind of in control of all of this, is that the people that actually wrote these bills was actually a young group of interns, about 20, 21 years old. They had no idea that there was even such thing as medibles or capsules or any of that. And so sitting in this meeting and talking to the actual kids who wrote these bills, and they're, you know, and actually had the opportunity to spend quite a bit of time with the actual authors of the bills and educate them, they were kind of in shock because they just didn't know what they were writing about. So, like I said, it's our job to do the educating, or we're going to get bad repercussions if we don't. Thanks so much.
Anybody on the panel want to add to that, or anybody from here have another question on that? Sure. There you go.
How does somebody get in the position to where they're writing a legal document about a subject they're not informed on? And how can we replace those?
It happens every day. Yeah.
I'm questioning how. You know,
well, I think what happened in this situation is that the Republican Party put together a group of young Republican interns and said, get to work on this.
I think they got their information from Shooty instead of from patients and caregivers. Okay.
Folks, just to encourage everyone to take an opportunity to speak to your senators or your House representatives on a statewide basis or on a national basis also. Some people are intimidated about that. They're afraid that they're going to go in and that person is going to reject their ideas or belittle them or make fun of them. We found that when we speak to these folks that they really are very receptive. When they hear patient stories, it makes a difference. Remember that everyone that's in the Senate and in the House, almost all of them are parents. Almost all of them are someone's brother or sister, and everybody's somebody's son or daughter. And when they know that there's illnesses in their families and they have personal stories of tragedy that they can relate to your particular also story of tragedy, they're more sympathetic than you might imagine. So those of you that have wanted to make those contacts but have been hesitant to do it, please let those fears drop and take the step. Once you do it once, you'll realize how easy it is, and then you'll be, every time we have a lobby day and we call people to Lansing, you'll show up. Not only is it empowering, it's also a cleanse of the soul. It really gives you a feel like you're participating in government, like you're taking a stand and you're participating in your own future. So any of you that have been considering this, please, let's get it done. And those of you that may be housebound or unable to make it out there to do those to Lansing, letters that you can write physically, email letters that you send to those, many of those opportunities exist for you, even if you're not able to travel. So please, I'd encourage you to do that. Absolutely.
And if you have, or even if you haven't especially ever met with your legislator, I want to mention some tools that can help you in getting up to speed and getting the confidence and empowering yourself to be able to do this. Americans for Safe Access, they have a website, and it's a very comprehensive website. So on their website, americansforsafeaccess.org or safeaccessnow.org, there is an online training center. And so they have a powerful search tool. You can search online training, and there will be a web page. They have about a dozen or more different videos on being a patient advocate or being a medical cannabis advocate. And on this, I would point you to the ABCs of citizen lobbying. And there's really three key things to remember when you're lobbying your legislator. Is A, would be accuracy. Provide them with accurate information. Be a resource to them of information. If you're a resource to them and you provide them accurate information, then they'll come back to you and ask you for more. And secondly, be brief. Legislators have a pretty tight schedule, and if you're lucky to meet with them, all the more so that you want to be respectful of their time. Recognize also that you may have something scheduled and something might come up and there's a vote in the session or they're unable to make your meeting. So typically you may meet with their staff. So keep that in mind to be as brief, to get your point across as quickly as possible. I learned from a Republican lobbyist from Maryland that if you can't give your spiel in 3 minutes or less, then you really haven't really made the deal, and so you're just wasting everyone's time. So keep that in mind. And then thirdly, ABC would be C, be courteous. Recognize that our legislators are there, and in large part to serve us. You may disagree with them, and I had a particular where I had a state senator from Ohio. Yeah, he was a Republican, very conservative. I'm sort of more sliding towards the middle of liberal. And even though we could agree to disagree on many topics, the fact that he said that his door was always open to me as his constituent meant the world to me, that he would listen to me, and eventually I was able to influence him. And so the ABCs, be accurate, be brief, and be courteous. And those are really the three key items that you need to remember in going into these meetings.
Great.
One last thing I wanted to add, if you are a person who isn't able to drive to your meeting, I know Rick said you could write letters, but you can also contact your closest MAC-affiliated center, and we've spent some time actually helping patients get to. So we'll provide you with a ride, transportation, help you get to meet with your representative if you want help with that.
Also, a lot of times these representatives come to their hometowns and their home areas to meet with constituents, and you can look out for those schedules. Oftentimes, hardly anybody shows up, so you can get there and get their ear for a little while. And also, if you don't feel comfortable talking to these people yourself, help to identify somebody who would be a good spokesperson and support that person and get in front of the representative as well. Rick Thompson, he's the editor of the Michigan Medical Marijuana magazine, also involved with the Big Daddies organization, and they've been having some legal scenarios lately, and Bill Schuette decided to join personally one of the suits out of Chesterfield, and that has been going on recently. There's been some hearings recently. Could you discuss that and some of those implications?
No. Just kidding, everybody. Listen, I plead the fifth. No, I did that plenty last week. Thank you very much. Let's give a little bit of background to those of us in the room who may not be familiar with the situation. Big Daddy's Management Group is a member of Michigan Association of Compassion Centers. We had at one time 5 distribution centers across the state of Michigan in 5 different counties. We have since dropped one of them because of additional pressure from that spawn of Satan, Oakland County. Oakland County, yes, Oakland County. But more importantly now, in our Chesterfield location, Chesterfield Township has taken the Schuette plan as he's been pushing it and tried to charge us as a nuisance in the community in order to shut our doors. Now, we've seen this successfully used in several places across the state previously, in Wayne County, in Midland County, Bay County. He's encouraged prosecutors to shutter businesses that cater to our community by calling them a public nuisance. There are really 3 legs of what constitutes a public nuisance. One of them would be if you denigrate the society itself, if you're just rotten to the core. The second would be if you are an illegal business, if you're operating a business that's not allowed by law, you could be a public nuisance. Or if you're a threat to the health and safety of the community itself, you could be a public nuisance. Well, we're not a threat to the health and safety. They've already agreed on that. And we don't denigrate society, so they've agreed on that too. So at this point, they've attacked Big Daddy's as an illegal business. And in order to prove that, they have to prove that the business model under which we operate is an illegal business model. A couple of months ago, we had a ruling in the Court of Appeals from the Compassionate Apothecary case, People versus McQueen and Taylor. I'm sure most of you are familiar with that ruling. And that ruling signaled the end to a lot of distribution centers throughout the state. The Court of Appeals dictated that there was one particular business model that was not acceptable under law under the Michigan Medical Marijuana Act. And because of that, many centers closed. But there are still quite a few that are open, ours included, with 4 locations. Chesterfield Township has yet to prove that what we're doing inside our distribution center is an illegal business activity, although they've tried. They originally initiated the lawsuit in September of 2010. Most recently, about a month ago or a couple of weeks ago, the Attorney General decided that it was going so poorly for Chesterfield Township that he needed to attach himself to the case in order to try and have some influence in order to result in a positive outcome for them. And therefore, instead of filing a brief, as he's done previously, where he just informs the court of additional information or additional attitudes or opinions that the Attorney General has, he actually attached himself to the case as a plaintiff. Now that's very unusual considering this is a civil case, not even a criminal case. Recently, we've had some time in court in front of Judge Foster in Macomb County, in Mount Clemens. And Judge Foster's attitude during the proceedings has been one of shuddered, guarded disgust. He feels that they're misusing police resources inappropriately, that the Michigan State Police crime lab's been used inappropriately, that the pursuit that they've taken against Big Daddy's management group in this suit has been improper in some instances. And he's even advised us on record in court that there are some actionable issues at stake here. The township has been a bad actor. They've utilized the police force to hassle patients that have left our facility. They've pulled them over, photographed their medicine, photographed their identification cards, then said, have a nice day, let them go. Although I'm glad that there's nobody in jail over that, it's an improper use of police resources. Once you start a case, you can't use police to get further investigative information. That's already supposed to be obtained prior to the case being initiated. So the Charter Township of Chesterfield has done a poor job of trying to prove that Big Daddy's is a nuisance. And we had a rally just this other day on Thursday. And for those of you that showed up to the rally, give yourselves a round of applause. It was a great turnout on short notice in the middle of a week in a county courthouse situation as opposed to a big Lansing thing. We had a good turnout. And what they learned was that the people of the Chesterfield Township support this. The people of Macomb County support Big Daddy's organization and what we do here. But there's a larger issue at stake. Should Big Daddy's be determined to be a nuisance, it's possible that that could trigger another closure, another wave of closures of dispensaries or distribution centers across the state. If the business model that we operate under is determined to be not legal, it could trigger that again. This is what Bill Schuette's counting on. He would like to finish 2011 the way he started 2011 by trying to kick all of the dispensaries out of the state. Now, if he's successful with this, then he will have a feather in his cap, and he will charge forward till 2014, and he'll get himself reelected, and he'll have Mitt Romney as president as well. What we're trying to do is to fight a battle that has statewide implications. The battle that we're fighting here is one for patients' rights, not about a single organization or a single individual or even a single business model. It's about being able to operate freely in your local communities with their approval. It's about being able to do things successfully and correctly within the framework and the guidelines that was established by the people in 2008. And it's also about standing up and saying we are not going to tolerate a misuse of power in order to pursue the people that are medical marijuana patients. So although this may seem like a battle that one organization is fighting, it has implications that go far beyond just that one particular court case. And that's why the Attorney General's office assigned someone to come out and help it. Now, we've had some small successes in court. We've had some depositions that were taken that were really very illuminating as to the nature of the prosecutor and the nature of the police officers. There's some questions as far as some of the behavior that they've done. But those are issues for another day. The issues that we have before us now are of protecting patients, making sure that they can get safe access to their medication without having to break the law, without having to be told on one hand that you're legal to possess but you're illegal to obtain. The definition of transfer as we read it in 2008 and 2009 and 2010 should not have changed in 2011 just because Attorney General Bill Schuette took office. Mike Cox had 2 years with this law and did nothing against our people. And Bill Schuette has spent his entire first year dogging us. This lawsuit itself will help to rectify some of those issues if it's resolved correctly. We've had a big break in this. The judge stopped the proceedings and said that we will not go forward with any other arguments because I don't feel like you've supplied the evidence to prove the first two issues in this case. And instead of allowing the case to continue, he stopped it and asked for briefs and oral arguments. Thank you for that, because that's very important. That means that he believes that the township and the Attorney General's office has failed. Now, of course, it's impossible to predict what a judge is going to say, and who knows what kind of politics goes on over a holiday weekend like Christmas and New Year's. You know, sometimes your neighbors get in your ear. Sometimes the Attorney General makes a call to you at December 27th and says, you know, you got a ruling in a couple of weeks. Don't you want to do this the way I want you to? So politics could absolutely enter into it. But I would like to believe in the system. I would like to believe in the man that's adjudicating this. The judge has been nothing but fair so far, and I'm confident we're going to have a proper ruling in this case.
Any questions?
Questions? Go ahead.
So was Leonard going to Judge Foster, thanking him
Actually, letters to Judge Foster would be an improper thing to do. Because he's a trier of fact, to communicate with the public on an issue like that and to take letters like that would probably be inappropriate. What would be more appropriate would be some letters sent to the Charter Township of Chesterfield or their trustees and telling them exactly how bad you feel about this, how they are not going to get your vote next time round, and how you think that they should use their powers to stop the lawsuit. And I'll take Steve's question, but I know Mr. Targowski, who's not the only attorney on this panel, because we have an attorney on the other end over here. But his opinion is much more important than mine in this issue. So let's hear what John has to say, and then we'll take a question from Steve.
What I would recommend doing is, I don't think any of the constituents in Chesterfield really know what that judge feels about them, and if the judge is actively making statements in court, those are all, you can get transcripts of those. Mm-hmm. Once you get transcripts of that, even just saying, this is how your township attorney, your township police department is behaving in court, that doesn't, because they don't really care if we disapprove, because we're the, we're the users. But if you have judges, if you can point to, and say, look, this is the transcript here, attached to Exhibit A, where that Judge Foster is denigrating your entire police department and saying that it's wasting resources, X, Y, and Z, and then attach another letter, show up at a township meeting and say, why are we paying for this? Yep. So that would be my advice.
Steve, you were next.
I just want to suggest that maybe perhaps that because Bill Schuette had attached himself to this civil case as a plaintiff, it would also be improper for him to call the judge or talk to anybody, any other people.
Oh, I would agree that it would be, what Steve's question was, since he's involved in this as a plaintiff, it would be improper for him to contact the judge. Well, I would agree with that, but I'm still not sure that's going to stop him from doing it. Yep, that's not the way it works. Mr. Horner.
Well, in an indirect fashion, how can this case not only impact dispensaries, but also caregivers at large?
Well, the question was, how can this case affect not only just the distribution centers in Michigan, but the caregivers at large as well? Having an opportunity for a ruling to be made on the distribution model between caregivers and patients could reinforce some of the statements made in 7259 and 7261, Attorney General's opinion letters, which restrict the caregiver-patient relationship in a way that would make it very difficult for the way that most patients and caregivers interact to be done successfulma. We've seen Bill Schuette specifically attempt to restrict how marijuana is grown. You heard John Targowski talk about the Bilsma decision, which ruled that cooperative grows are not in favor in the court system in Michigan. There are a lot of ways that a decision that came down with Schuette's point of view could affect caregivers. It could change the relationship that you have with your patients completely. There may not be any intermediaries allowed. There may not be anybody else able to handle cannabis. They could make decisions about whether cannabis is allowed to be grown in residential areas or exactly what they want to do. The ultimate goal, I believe, for the Attorney General is to get this out of circuit court and into the Court of Appeals like he did with McQueen. That way, when there's a decision made there, it would absolutely be binding on the remainder of the state. A decision in circuit court is really only binding on the other courts in that circuit, even though it's used to frame decisions statewide. It is not a compeller of action. So he would like this to go to the next level of the court system and get his decision there. Now, what would be great for us is if we had a decision in the Court of Appeal, in the circuit court, that empowered distribution, that empowered patients and caregivers to act more like we did in 2009 and 2010. The question becomes exactly how that decision would be framed, what parameters it would be wrapped around, and how broad Judge Foster wanted to be with his ruling. It's the belief that he's going to be very narrow in his interpretation and trying to find that exclusively to the instant case, to what's going on in front of him. But we would certainly hope that it would be more empowering than that.
Is that Monday night meeting in Chesterfield in regard to the township, is that tomorrow?
Yep, there is a township supervisors meeting in Chesterfield Township tomorrow evening at 7 o'clock. There'll be an email out on some of our listservs, our Safe Through Mich, MI Normal, the MACC list. And we're calling for folks to come out to Chesterfield Township to show their support once again. And this is exactly to do what John had suggested, to show up at the Planning Commission, at the Charter Township Commission meeting, show the township trustees, that there is a big show of support, and have an opportunity during public comment to actually give your 5 minutes of your opinion out there. Let them hear exactly what the people feel, because if they're only listening to themselves or each other, they're really not getting a good idea of what the public believes. Yep, and it's also much better if you're a township resident. Remember that although you can register to speak just by showing up, you don't have to register to speak. You can show your support just by having your face there and your butt in your chair. But you don't have to speak if you do, though. It's better if you are a township resident. Any other questions on that? All right, Jamie.
Thank you. All right, Tim Beck. He was involved before this law came into effect in getting individual cities to pass medical marijuana ballot initiative, or putting ballots on for that and passing, and that helped to set the stage for this. He also did everything correctly in order to get a ballot in Detroit about kind of a decrim, and it wasn't allowed on there. And that has gone through some different legal scenarios and stuff like that, so I'd like for him to discuss that, and also add in some of the efforts that are taking place in Kalamazoo right now with the LLEP thing, and maybe John can talk about that as well.
Hey, thanks, Jamie. Glad to be here. I want to kind of preface a little bit. I think all of us are aware that there are disagreements within our community about how things should be prioritized and what we should be doing, and on and on. And I guess for me, when I got into this back in 2001, my ultimate goal in the end, if I live long enough, is full legalization. Okay. Because I think that's the only solution to the so-called marijuana problem. I say so-called, okay? That way we wouldn't have this kind of confusion and so on and so forth. But at the same time, oftentimes you just can't get everything you want right away. So way back when, I became aware that the concept of medical marijuana is much more acceptable within the public mind and so on. You have a better chance going that route than to go for full legalization right away. So I decided to kind of take that particular approach. And in 2001, we attempted to get medical marijuana on the ballot. Well, we screwed up. We did something. We didn't have the best legal advice in the world, and the petition wasn't properly constructed, so we got all the signatures and we didn't get on the ballot. And then we appealed to the Court of Appeals and Wayne County Circuit Court of Appeals, and we lost all the way. And at that point, we decided to cut our losses and just get it right next time. So then in 2003, we went back again to get on the ballot in 2004, and this time we succeeded. We did get the legal language correct, and then it won with 60% of the vote. And we used that same technique in Ferndale, Flint, and Ann Arbor and Traverse City were a little bit different in terms of their legal models. It's not appropriate to go into all that at this point. But bottom line, then ultimately we got medical marijuana passed statewide. Now, like for me, I guess one of the problems that I in terms of strategy, military or political or otherwise, is often to take the offensive rather than react. You get them to react. You make the move. You be the aggressor, or you be the one that's assertive. And so what I decided to do is continue that struggle after medical marijuana is now passed and so forth. I decided to go back and make possession or use of an ounce or less of marijuana on private property by anyone who attained the age of 21 years in the city of Detroit. It would no longer be a crime under city ordinance. And a couple people helped. Matt Abels in the audience helped out with that. We had another guy, David Farman, who was kind of a passive investor. He put a little bit of money into the effort. And again, we used the same technique as we did for medical marijuana. What we did, like the city of Detroit specifically, and as well as Flint and a number of other cities, Ferndale, they have their own anti-drug laws, on the books, replicating state law. And they did that in order to capture fine money for their courts. Other cities, like Kalamazoo, for instance, does not have any anti-drug laws that I'm aware of, except maybe for paraphernalia or something. So what happens if you're charged in Kalamazoo with a marijuana crime, it's processed basically in state court, and the fine money and so any fine money goes to the state, not to the city, all right? So again, we did everything right this time, but we had a new administration in there, and they decided to say, F you, buddy, it's preempted by state law. We can't do that. Sue us. Well, that's ultimately what we had to do. And this case, we lost in Wayne County Circuit Court, and then we went to the Court of Appeals, and we got one of the best law firms in Michigan, Honigman Miller, Schwartz and Cohen, they're called. We were able to get their basic lowest level discount rate of $375 an hour, okay, to take this case. They charged DTE Energy $850 an hour to do their legal work. So, in any event, these people are very good, and we had oral arguments on the 10th of August in the Court of Appeals. Still no ruling has come down, and it is such an interesting case. It's going to be a published opinion. And this is very important because that will be settled law because the case is so unusual. So what that means is any lawyers practicing election law and even law students studying in law school will be studying the Coalition for a Safer Detroit versus the Detroit Election Commission. So we hope we will win because that'll preserve the rights of all cities, because the city of Detroit, in a weird argument, is saying even though they passed their own law, they can't amend their own law. Bizarre, right? Real unusual. And they're doing it, yes, and they're basing it on an argument that says that, on another case that says no municipality can prohibit what state law allows, and no municipality can allow what state law does not allow. Yet, they say now, and then the implication, of course, is they're saying if we amend that law, then we're now allowing marijuana. So, and we're in violation of state law. So there is no legal precedent in Michigan on this. So it will be a published opinion, and it may even go to the state Supreme Court. So it's a very interesting situation. Again, we're not going to be on the ballot, obviously, in November. Again, the next election that they're going to have an election in Detroit in August. Okay, that will be the primary. So we're just letting it play itself out. I believe we're going to win because the polling for where the public is much, much more receptive to the concept of the possession of small amounts of marijuana is okay, all right, where big dealers that are selling to kids and on, and you've heard all this stuff before, they don't want legalization, but they're much more amenable to letting small-time folks, off the hook. And we believe, given the demographics of Detroit, we're going to win big time. On that one, if we get to the ballot. So that's what's going on with Detroit. But again, if we win, it's going to have I think it's really going to send a very, very strong message to characters like Bill Schuette and some of these conservative Republicans, because their theory is that the people were tricked, in the last election with medical marijuana. Nonsense, BS, okay? So we're taking it to a whole other level. And that's the same thing going on in Kalamazoo. Now, my good friend Chuck Ream and his buddy Chris Childs and John, I know, has been involved in this. They're using a different model because there's no law against marijuana in the Kalamazoo City Code. So what they're doing is amending the charter to make possession or use of about the same amount of marijuana, something like that, the lowest law enforcement priority. So now that has made the ballot. That's pretty much unchallenged. So I'm going to guess that it's going to win. I mean, you never know, but I think it has a very good chance. And oddly enough, the Kalamazoo Gazette, they don't like it. They say, it means nothing, and it's just unimportant, it's just symbolic and all that. Well, great, because I suspect that people, if they say, well, gee, it's just symbolic, means nothing, fine, they may just likely feel safe to vote yes in the privacy of the voting booth. So that may win. And that one will also send a big punch, to Bill Schuette and some of these characters that are on this jihad, about marijuana and so forth. So we're taking the fight to them. We're not just reacting. We're going on the offensive with this stuff. So that's kind of it in a nutshell. John, would you want to talk more about it?
Briefly. Thanks. Kalamazoo lowest law enforcement priority is something that an individual named Louis Stocking and I wrote about 2 years ago. And the journey to the ballot was one where, kind of like some of the other things that Tim was talking about in the state, I mean, it's sort of a two-part process. You get the signatures, and then not all signatures count, but they last long enough, and you can get them, and they're good for the next election. And that's really why it's, in the 2011 election. And what I found pretty remarkable is that given the McQueen case and given, like Tim said, given the Attorney General and a lot of judges and people in law enforcement sincerely believe that the voters were hoodwinked, that nobody wanted dispensaries or marijuana stores or, farmers markets or drug to driving, or they just wanted people pretty much in end-stage terminal cancer to have marijuana. They didn't want, almost anybody else, at least ambulatory, to have it. And so it's part of a bigger conversation. We have a Gallup poll that came out, and we have, I think, the beginnings of ballot signatures for other statewide initiatives for 2012, including some rumbling of something here in Michigan. So it's important to have it because once you have that winning, you have bigger, you have Marijuana Policy Project, you have larger, big donors that come in that helped us with the medical initiative. We become, a place where they can prove their point by. Go ahead, Ben.
So I know this is a complicated question, but why didn't you go for legalization versus lowest priority in Kalamazoo and same thing in Detroit?
Well, in Detroit, they're actually trying to get what we already have in Kalamazoo, which is a city with no overt marijuana prohibition on its ordinances. If you're in the city of Kalamazoo and you get caught with marijuana, you're going to get arrested, or you're going to get cited, I should say. You're going to go to court for it. But it's going to be the state of Michigan as the plaintiff, not the city of Kalamazoo. So essentially, we already have what Detroit wants to have. It may, once Detroit gets it, if they get it, I'm sure they will. But once they do, it may not effectively legalize marijuana, in Detroit because it's not overtly creating a safe harbor for its possession under the city ordinance. It's not regulating, providing any revenue or overt, licensing and so forth and distribution. So I don't really think it's positively wanting, legalizing it. It's just removing penalties for it, which is, like I said, exactly what Kalamazoo has now. I don't think Kalamazoo is, particularly like some sort of Amsterdam, believe me.
Any questions for Tim, John, on this issue?
Well, to go along with that legalization effort, isn't this kind of the time to do this?
I want to talk about this issue, in more in depth. And so let's finish up with Tom on another question, and then that's what I really wanted to talk about next, and bring it all the way down the panel as the possibilities for this year. Is there anything else on LLEP or Tim's Detroit initiative?
Sure. Yeah, let me add one thing. See, what we're trying to do is make it where it's absolutely a waste of time for the city of Detroit to enforce laws regarding small amounts of marijuana. Because what they're doing right now is a really neat little scam, let's put it that way. And the ACLU is taking a hard look at it. But what they're doing is that they'll find a joint, on somebody or in their car or whatever. And then what they're doing, the city of Detroit then seizes their car. Okay, and then holds it hostage for $900. If you want your car back, you got to pay $900 and/or then sue them. So most of these poor folks, in Detroit, that get busted, they just turn over the car, to the city, and the city, resells it or sells it for scrap, and they get a ticket, and of course the person never shows up. Usually they don't show up in court, to contest it. So now they're guilty of a misdemeanor, and they have a criminal record. So it's much more easier to pop them, for something else later. So what we're doing is cutting off that revenue stream from the city of Detroit, from this automobile scam that they're running. That's what that is the motive here. So once there's no money in it for them, we're hopeful now, even though they can charge them in state court, Wayne County Circuit Court, etc., there is no value for them to do that. So we want to end this little automobile scam. That's the deal. Okay?
There's a question in the back. Go ahead.
Correct me if I'm wrong, but then the measures within a city would only really pertain to the city law enforcement. It would not pertain to the state law enforcement, correct?
Correct. Okay. Local ordinance laws are unique to that particular community, whether it's a county rule or whether it's a city rule or a township rule. State laws, of course, cover all 83 counties in Michigan. But as we've seen in Grand Rapids, oftentimes one particular community makes a rule, and then the smaller satellite communities around them will follow suit. We've seen when Grand Rapids passed an ordinance that was not very favorable to medical marijuana. A lot of other communities adjacent to it or in that same county did similar things as well. So.
Any other questions on these? Okay, Tom Levine, he's of the law firm. Cannabis Council, his partner Matt Abel is here as well. And I guess right now, can you discuss how, and we'll talk about the ballot initiative issue right after this in a little bit more in depth, but discuss about how your hands are being tied in some cases. You're not able to offer the best criminal defense as you would think under this law because you're being circumvented, and how that's been an issue for not only you, but for lawyers in general trying to help people out.
Yes, that's true. It's unfortunate, but the courts have been ruling oftentimes to cut off litigants from even claiming that they're a patient or even mentioning the Michigan Medical Marijuana Act. Now, how ridiculous is that? Now, they're really, I think that we're all here in sort of a standpoint of ready to fight because they have so dishonestly administered this Medical Marijuana Act on every level to treat it so strictly and all of this. So I think that one thing that worked for me I won a jury trial doing this was not bringing the Section 8 motion to dismiss in order to keep it for the jury, and the juries will go our way. But these judges also need to be replaced. We need to cultivate judges. We need to cultivate people to run for judge. They're right amidst us. That's an important aspect, as well as the political aspect. We need to join forces with our political allies, both in the National Cancer Society, everywhere from the breast cancer and the different groups that we are a part of. We should show up together in a united front with all these different groups. My wife and I have been occupying Detroit with the cannabis cures. Our placard said cannabis cures, And it's been getting a lot of positive reaction. People have been seeing the connections between the 99%, 1%. And we all see these different connections. But in terms of the possible fight back, we could either end prohibition altogether, or we could do another initiative in order to protect the very patients that the Medical Marijuana Act was intended to protect in the first place. What are we supposed to do? Say, we really meant it when we said, shall not be subject to arrest. It's almost ridiculous because we're dealing with a dishonest broker on the other side. So when we sit with these legislators and we say, vote no on any of it, these proposed bills, and here's the issues we're seeing. Doctors should not be dragged into courts, for example, for a Section 8. Section 8, the first element says that a physician has stated that the patient would benefit. That can be obtained from a physician certifications, a self-authenticating document. Why not have that as the standard of evidence? I always argue that to try to protect the physicians, because it becomes economically impracticable for them. If they're dragged into court and having to close down the office every week, that can be very expensive with a physician's practice. So that's a bill that I propose when I've sat with my various legislators and their assistants, and I've promoted that idea to make it clear that doctors shouldn't have to come in here. They've already stated it here. And the judge and prosecutor should not be practicing medicine without a license as they cross-examine the doctors as it concerns the private medical conditions of these patients. It's the theater of the absurd. And it's the new Jim Crow. And we need to call them out on this shit. But The 12 plants we already have in the Medical Marijuana Act. So what if we were to propose in the initiative 12 plants again, but the weight is too low. It doesn't correspond with those 12 plants. So what about 2.5 kilos? 12 plants, 2.5 kilos. It kind of is like the 2.5 with no penalty. And then if you go over the 12 plants or the 2.5 kilos, it's just a civil infraction of $500. And if you go over 50 plants or kilos, then, maybe then we start into a misdemeanor, as a compromise. There's a side of me that wants to just say, end prohibition altogether, because the pendulum is such that we won in 2008 with medical marijuana. Now they've come back totally dishonestly, taking away our rights as well. The swing of the pendulum, most natural to me, is completely end prohibition like this now. And then as a compromise, the pendulum we may have to meet here in the next election cycle. But if we, looking at the polls, if they're truly good on the numbers and stuff, and I minored in mathematics, so I have an inherent distrust of all polls. But if you come halfway on the pendulum, this might be a more reasonable way to even protect the patients under the Michigan Medical Marijuana Act and the caregivers by protecting us all up to the 2.5 kilos in the 12 plants. Seems like a fair compromise to me. Because 12 plants can indeed produce more than 2.5. Actually, I'm being conservative here. For our good farmers here in Michigan, which we have been long, we could have gone higher. So that kind of represents a compromise to me. But, and repealing all the acts in which they prohibit it in various ways, as well as the civil forfeiture. The civil forfeiture, one inhibition is these people's money and everything have been taken from them. So it's hard for them to pay a lawyer to have the defense and to even get around without a car to go post their bond at 10% of the value of what has been taken, and at least $250 just to get your money back. Has to be done within 20 days. And they're playing unfair on many levels. There was an Omni agent down in Adrian who came and advised the client, you have to build your fence thus far, almost like a prison yard barbed wire at the very top, enclosed locked facility under the sun. Under those circumstances would be okay. He does it even higher. I mean, this thing was impenetrable. And he then takes off the Omni badge, puts on the DEA, comes over and busts them, foreclosing on, seizing the house, the property, everything. He said, well, what I advised you of before, well, that's when I was wearing that badge. I got involved, I think that there was that story down there where there was some crooked cops involved in the forfeiture, policing for profit. Yeah, this is down Monroe Way. And
both.
Yeah, they were in both. So he might have had to. But anyways, another interesting issue at hand is husband and wife are being denied to enter the same garden. Harkening back to Adam and Eve. I mean, this is fundamental shit, people. You're going to get in my way? You're going to put a wall between me and Andrea? I don't think so. This is getting into the very intimacy of the marital relationship. Our right to privacy is at stake. If this is not contained within the penumbra of our right to privacy, I don't know what is. We must cut off all probable cause for them to invade our very privacy. And no local control. They screw it up. And our communication plan and our PR is perhaps at the very crux as a leg in this battle, perhaps most important of all, because Large corporate media has been on their side for 90 years, people. They've waged the war. They've been the very sword at times in the war, which has struck at a blow to the heads of humankind to cut us off from this natural resource. Big paper Hearst did not like the competition hemp paper provided, a superior quality, but had we been following that more sustainable development route for the last 90 years, instead of clear-cutting our old-growth forests, the very lungs of Mother Earth, would we be in the same global climate change to this degree today? I ask you. Do the math. Now, so this battle unites on many levels. We have dual sovereignty. The state of Michigan is its own sovereign. The federal government is its own sovereign entity. The state of Michigan has evolved its own jurisprudence of criminal law through its time, coming up with its own defenses, for example, entrapment, before it existed in federal court. There's no inconsistency here. Preemption is a red herring argument. Dual sovereignty is why we're within our rights, and it's why these local officials cannot be penalized for carrying out their duty. They serve their sovereign, the state. See Amendment number 10 of the Constitution. And as well, look at the Controlled Substances Act, which states right within it that it does not intend to exclusively occupy the field with respect to this, leaving it to the states to do so as they see fit, within the best health and welfare and safety of the people of the state of Michigan. Right within the findings of Section 2 of the Michigan Medical Marijuana Act, it declares and it finds this is within the best health, safety, and welfare of the people of the state of Michigan. So these local governments have no business finding otherwise. And further restricting these dispensaries and safe access, if acquisition, which is the very first term as the Michigan Medical Marijuana Act defines medical use, the very first term is acquisition. If that does not imply sale, what does it? Acquisition is the very first term. McQueen doesn't even address that acquisition is one of the terms defining medical use. However, McQueen also provided a new definition we didn't have before, under which dispensaries can move forward as a service industry, preparing the marijuana in one of the ways it's very commonly consumed. So pursuant to McQueen, dispensaries can exist right now. But there's where we're losing that PR, that communication plan that we have to come to grips with. I see a lot of good production, a lot of social media expertise in the young generation, especially in this community. And we're going to kick their ass here. I mean, Facebook and viral videos is what brought Cairo to revolution. This is a new day. And even the amount of money that it used to cost to get a ballot initiative done has changed because of this new form of communication and networking. We can broadcast text everyone and have flash mobs and stuff. We can kick their asses. It's a costly war, and here we have this super committee of which the constitutionality fails to muster. A super committee making these decisions on extra legislaturely like this. It's ridiculous. But anyways, they want to cut some costs, put the pressure.